For watching On Point with me. Today we have two On Points. First, we look at how Vice President taken on the judiciary. Second, we decode how the Supreme Court has maintained status quo on the Waqf amendment law. Now the headlines. Emir rubbishes Pakistani Army Chief Munir's comment on Kashmir. Supreme Court allows 25,000 sacked West Bengal teachers to continue in their posts till the selection of new teachers. Trouble for Tamil Nadu Minister K. Ponmudi for his comments on Hindu symbols. Madras High Court directs police to file an FIR against him. Karnataka CM Siddaramaiah chairs special cabinet meet to discuss caste census. War of words escalate over cow deaths in TTD Gaushala. The TTD chairman and YSRCP leaders stage protests. Maharashtra government's big move amid growing language row. State government makes Hindi compulsory as third language from class 1 to 5th. CBI raids AAP leader Durgesh Pathak over alleged foreign funding violations. Donald Trump blocked a planned Israeli strike on Iranian nuclear sites in favor of negotiating a deal with Iran to limit its nuclear program, says a fresh report. President Vladimir Putin thanks Hamas for releasing 3 Russian hostages captured during the October 2023 attack on Israel. Vice President JAGDEEP Dhankhar has taken on judiciary head-on. He not only criticized a recent Supreme Court order directing the President to act within a specific time frame on bills sent by the governors for consideration, but also said that the people's faith in judiciary has gone down as per a survey.
Boys and girls, when Article 145(3) was there, the number of judges in the Supreme Court was 8. 5 out of 8. Now 5 out of 30 and odd. But forget about it. The judges who issued a mandamus virtually to the President and presented a scenario it will be law of the land have forgotten the power of the Constitution. How can that combination of judges deal with something under Article 145(3) is preserved? It was then for 5 out of 8. We need to make amends in that also now. 5 out of 8 would mean interpretation will be by majority. Or 5 constitutes more than majority in 8. But leave that aside. Article 142. Article 142 has become a nuclear missile against democratic forces. Available to judiciary 24/7.
The Vice President also said that it's time to break the can.
And the survey indicated, it was by a media house, that public confidence in the institution of judiciary is dwindling. It is fundamental for success of democracy that its 3 fundamental pillars, legislature, judiciary and executive, are above board. They are transparent. They are accountable. They exemplify to the people at large the highest standards to be emulated, and therefore the principle of equality before law has been disregarded. It is fundamental to our democracy. It is nectar of our democracy. Time for us to enforce it.
Calling it a worrying development, he said that India was never where judges function as lawmakers, the executive and even a super parliament. I'll play out this bite a little later. Let me introduce Advocate Desh Ratan Nigam. Thank you so much, sir, for joining me. The Vice President has said that it's time to break the can. I mean, so he has literally taken on the judiciary. I don't recall last time when the Vice President of the country has spoken so bluntly about the Supreme Court of India.
Well, Karthikeya, let me point out first and foremost thing, Supreme Court is not supreme. It is only supreme so far as the hierarchy of the courts are concerned. The will of the people is represented through Parliament, and it's time that people should speak bluntly. Let me tell you, as a lawyer, when we interact with the clients, the perception of the judiciary has really gone down. It is considered a place where delay takes place, the justice is denied, and also at the same time it is corrupt. There is a lot of nepotism in appointments. Therefore, if you look at the original Constituent Assembly debates for appointment of judges, where it was clearly said the executive will appoint, and they only wanted to give it to the executive. But out of discussion, it came out that let the executive consult the Chief Justice. This was the original position in the Constitution. I fail to understand as to how consultation in any language, forget about English, can become concurrence in one case, then taking over the appointment through a collegium system exclusively, where there is no accountability of appointment. Nowhere in the world, any country where judges appoint themselves, nowhere in the world, they are accountable to the people of the country through Parliament or elected
Sir,
bodies.
are you saying are you saying that there's a judicial overreach in India today?
Yes. The judiciary is taking over legislative functions, executive functions. They want to appoint Chief Election Commissioner also. They want to appoint CBI Director also. These are executive functions. Executive is best suited. Supreme Court does not have the wherewithal to judge a person for appointments. In fact, these are encroachment on executive functions. That is why Arun Jaitley clearly pointed out while bringing out NJAC that this is the tyranny of the unelected. Clearly, we don't know what is the procedure in the collegium system, the appointment of judges. The only people, bring out the fact that this is how the independence of judiciary is maintained. Let me tell you, independence of judiciary is maintained by making the removal process of judges very difficult. This is how it is done. The removal of judges of High Court and Supreme Court is very, very difficult. This is how independence of judiciary is maintained.
There are two more issues, sir. Let me play out the bite of JAGDEEP, Dhankhar, and then I'll come to you. Has judiciary overstepped, sir, or has the judiciary corrected the overreach of the governor, Mr. Ravi, who was actually speaking on very hard political lines in Tamil Nadu? Let me play out those two bites of JAGDEEP, Dhankhar, sir.
Very frequently, we are finding that executive governance is by judicial orders. When executive, the government is elected by people, the government is accountable to Parliament. The government is accountable to the people at election. There is a principle of accountability in operation. In Parliament, you can ask questions, critical questions, because the governance is by the executive. But if this executive governance is by judiciary, how do you ask questions? Whom do you hold accountable in election? Time has come when our three institutions, legislature, judiciary and executive, must blossom. And they blossom best, and best for the nation. An event happened on the night of 14th and 15th of March in New Delhi at the residence of a judge. For 7 days, no one knew about it. We have to ask questions to ourselves. Is the delay explainable? condonable? Does it not raise certain fundamental questions? In any ordinary situation, and ordinary situations define rule of law, things would have been different. It was only on 21st March, disclosure by a newspaper, that people of the country talked as never before. They were in some kind of limbo, deeply concerned and worried at this explosive, alarming explosion. Thereafter, fortunately, we had input from authoritative source, the Supreme Court of India, and input indicated culpability. Input did not lead to doubt that something was amiss, something required to be investigated.
I'm also joined by Advocate Nikhil Jain. Nikhil, is it a case of judiciary overstepping or judiciary doing the correction, because the Vice President has actually taken on the Supreme Court of India on the overreach in context of the President being time framed, the 3 months. So how do you see this particular speech, in which he has listed number of issues, which is of confidence in judiciary trying to run the executive, trying to interfere in the legislative manner, and trying to actually bring the ambit of the President in their, I would say, decision-making role, which he clearly objects in his speech.
So, Karthikeya, I don't see it as a case of judicial overreach. Rather, I see it as a very sad case of the Vice President of India not understanding the constitutional scheme. So, you may have a government order of precedence or whatever, but under the constitutional scheme, the President is not above the Supreme Court. The Supreme Court is not above the President. There are measures of checks and balances. There are separations of power. And the constitutional scheme of the country explicitly provide for the constitutional courts of the country, including the Supreme Court and the High Courts, to do something which is called as judicial review, which is under the writ jurisdiction, wherein they can command or modify orders of the executive, which is the President, the Prime Minister, the Chief Ministers, the governors, as well as of the legislatures, which is the Parliament and the state assemblies, which is how the Supreme Court time and again stays or cancels or modifies legislation that has been passed or directs the government to do a certain thing. So for the Supreme Court to tell to the President, who's essentially the head of the executive at the Union, to make the decisions in a time-bound manner and not make it an arbitrary exercise wherein by the name of considering something you're essentially vetoing it, that is perfectly within the rights of the Supreme Court. The Supreme Court has given similar directions in the past to state assembly speakers, and that is how the constitutional scheme functions. Also,
but Nikhil, I have a point to make here. Does autonomy mean complete independence from the system? The appointment process is completely opaque.
No, we can have a separate discussion on how the collegium system and the appointment system of the Supreme Court works, Karthikeya. And let me also again remind you that at the end of the day, it is the President who appoints people. And there have been many cases in the recent past, wherein names have been given and recommended by the Supreme Court collegium, but people have not been appointed or their names have been sent back and the appointments have been delayed, seniority has been interfered with. Again, we can have a discussion on that separately, whether the appointment procedure in the Supreme Court or in the Constitutional Courts is correct or not. Personally, I believe it's not the perfect procedure, but whatever different mechanisms we've seen so far, the one that existed earlier, the one that has existed currently, is the best of the worst. That is how I like to put it. It's not perfect, it's not right, it needs correction, but that is a different discussion. The discussion at hand right now is that whether the Supreme Court under the Constitution is empowered to give orders to the President or the Prime Minister and the Union government, and the clear answer to that is yes. They've done it in the past with Congress, with BJP, with every sort of government. That is the very constitutional scheme. The President is not above other constitutional institutions like the Supreme Court. There is a system of checks and balances. If the Vice President today comes and says that the President is the highest constitutional dignitary in the country and therefore nobody should have the power to sort of direct him, then are we living in a constitutional democracy or an autocracy?
Okay.
There is a system of checks and balances. Okay. And one small point I would like to make, one very small point, I'm sorry. Article 145, he talks about, despite the fact that he's a senior advocate, I really do not understand. He was a senior advocate. I really do not understand how does he not know that the Constitution bench of Supreme Court has nothing to do with the initial strength of 8 and a majority of 5. Constitution benches are constituted by 5 judges. It is not a majority principle with the number of judges in the court. So 8 ki majority 5 hai, so we'll put 5 judges. That is not how it is. If 3 judges in a constitution bench of 5 rule in favor in a particular direction, that is determined as the order of the constitutional bench of the court.
Mr. Nigam, is this the correct legal position which Nikhil is saying?
No. I think if you have to understand the intention of the constitution, you have to go into the Constituent Assembly debates. Not many people read that. That's the irony of the situation. One of the best advocates, if you look at it, they don't go into the Constituent Assembly's debates. And I'm not sure whether Mr. Nikhil has read it or not. I certainly have. While, making the appointment of judges, they were very clear while discussing that its power should lie exclusively with the executive. And later on, they thought, while discussing it, let it consult with the Chief Justice of India. That is what they brought in. Consultation with the Chief Justice. It was only consultation. How consultation, as I am repeating, could become concurrence under the Indian Constitution has baffled me till now. Then system was taken over as collegium, appointing themselves to become a judge in their own cause. Of the judge who is under investigation, the Supreme Court is investigating itself, its own biradari, and then will recommend a person, recommend whatever actions is to be taken. It has to be done by an independent organization to investigate somebody. So these are the fallacies which are there, and this needs to be corrected. This is high time. Judiciary, again, I am repeating, is not supreme. It is only supreme so far as the hierarchy of the courts are concerned.
Actually, if the entire speech of Mr. Dhankhar is, the impression you get is that the judiciary is becoming footloose. Is that correct impression of the judiciary?
See, that is how it is happening. You can't direct the president. Constitution provides pocket veto to the president as a means of checks and balances. Please understand how many vetoes are there for president in the constitution, which is clearly provided. A pocket veto is one of them. There is no time period given by the constituent, and it was debated in Constituent Assembly also. Where no time period. This is the system of checks and balances. Supreme Court cannot say, because ultimately the government is responsible to the people. If they do something wrong, the people will punish them through elections. Now, if the Supreme Court does something wrong, then who are they accountable to? The collegium system? What can you do against a collegium by an executive or the parliament? Nothing. The only way is removal of judges, which is a very difficult process, rightly so, because that ensures independence of judiciary. The appointment has to be controlled by people who are accountable to the people of this country. It is nowhere in the world, no country where judges appoint themselves. This is the only country where judges themselves through a judgment have taken over the appointment. Whatever the political system is, at least they are accountable to the people.
No, but
this is opaque.
If in today's context, sir, Mr. Dhankhar was talking about the fact that the power of the executive and legislature is being encroached by judiciary. I think that was at the heart of his conversation. If this entire speech was moving on that line. So my question to Nikhil is, do you think that, again I would repeat the word, in all sincerity, is judiciary becoming footloose?
Absolutely not. If you ask me the question, is judiciary perfect? No, but the judiciary is not becoming footloose. They are doing their job to keep the government in check. That is their role in society under the constitution. And also to Mr. Nigam's point, he's again and again going on the process of appointment, and I've already made my position clear that I don't think it's a perfect process. But what we're talking about right now is the power of the Supreme Court to indulge in judicial review of actions of the president and powers of the president. Those are two very distinct points. And what the Supreme Court has done right now is completely all right. So far as the concept of pocket veto is concerned, see, I agree with Mr. Nigam that there are these, ideas in the Constitution about a pocket veto and how such powers are given to the governors and the president. But that pocket veto cannot mean the unilateral power to decide or not decide. Let's, think of a situation where the president, who is indirectly appointed by the political establishments of the country, does not pass any bill. Let's say the Lok Sabha has passed the bill, the Rajya Sabha has passed the bill, and the president says, oh, listen, I have a pocket veto. I'm not going to give assent to it. So the bill remains a bill. It does not become an act. What do? That's a constitutional crisis, isn't it? This is pretty much what is happening right now, that you have a state assembly passing law on a matter which they're completely competent to pass a law on, but the president not agreeing to it. Are we forgetting that state assemblies in this country are elected by the people? They're the voice of the people. If they're doing wrong, the people will vote them out. Who is the president to tell a state assembly that, no, listen, the law that you've passed is not good, I'm not going to pass it? He can consider it. He's the highest constitutional dignitary, but he can't just sit on it forever and say that the bill does not become an act.
So you know, that was the first part of our conversation. The second part of the debate is similar because it is again becoming centre versus judiciary. Mr. Dhankhar spoke in context of cash being discovered in the residence of a judge. He spoke in context of the controversy which started by Ravi because he sat on 10 bills, the governor of Tamil Nadu. But today, on a very important matter, it seems that the Supreme Court of India has taken a contrarian view. And the contrarian view has been taken on the Waqf Amendment Act. Both of you gentlemen, please continue to stay with me because both these debates are interlinked. What JAGDEEP Dhankhar, Vice President of the country, has spoken is part of a larger debate which is taking place. And the debate is it going to be centre versus judiciary in most of the matters? Because in the context of Ravi, the popular will of the Tamil Nadu Assembly was cited. Now in this context, the shoe is on the other foot. Again the logic is popular will of the country going to be constrained in the court? That the proposed modification of the Waqf Amendment Act as of now is on hold. The Supreme Court has asked the centre to maintain status quo till next hearing on May 5th. A 3-judge bench comprising Chief Justice of India Sanjeev Khanna and Justices Sanjay Kumar and K.V. Viswanathan passed an interim order on more than 70 petitions on the constitutional validity of the Waqf Amendment Act 2025. The apex court took on record the centre's submission that the non-Muslims won't be appointed to the central Waqf councils and state Waqf boards till the next hearing. Also, the status of the Waqfs, including Waqf by user already declared by notification, will not be changed for now. So let me recount what the Supreme Court has said. 1. Supreme Court grants centre 7 days to file response to the petition challenging the constitutional validity of the Waqf Amendment Act. 2nd, petitioners can file their rejoinder within 5 days after that. Status quo must be maintained on key provisions of the controversial Waqf Act. 4th, inclusion of non-Muslims in the Central Waqf Council and Waqf Board is on hold. And that is also at the center of the debate. It lies in the center of the debate. 5th, provisions on denotifying properties declared as Waqf by courts will not be acted upon for the time being. Now let me play out the bite of advocate Barun Kumar and Abhishek Singhvi, and then I'll tell you what the center had said.
माननीय अदालत ने कहा कि जो वक्फ व यूजर है, जो रजिस्टर्ड हैं और गैजेटेड हैं, उसको गवर्नमेंट डी नोटिफाई नहीं करेगी टिल द नेक्स्ट डेट. तो बड़ी इंपॉर्टेंट बात है कि जो रजिस्टर्ड एंड गैजेटेड हैं वही सिर्फ डी नोटिफाई नहीं होंगे, उसके अलावा संशोधन के हिसाब से सरकार कार्रवाई करने को स्वतंत्र है और जो संशोधित कानून है उस पर किसी भी तरह का अंतरिम आदेश नहीं है और अगली तारीख तक भारत सरकार को अपना जवाब और उनको जो भी डॉक्यूमेंट्स देने हैं वो देने होंगे.
This is intended in any manner to prejudge the issue, which has been heard at length yesterday and today, and will also be heard for further interim relief, etc. on 5th. The Waqf Amendment Act is not an exercise in efficiency as it pretends to be. Religious autonomy is being reduced to state-administered protocol, and community rights are being redrawn with bureaucratic pens. Let us be clear, this is not about improving institutions, this is about infiltrating them, controlling them and closing them.
Now what the centre said. 1. Solicitor General Tushar Mehta said respondents would like to file a preliminary reply within 7 days. Mehta argued that the legislation was brought by the government in response to lacks of representations. 3rd, staying the amended legislation would be an extremely harsh step, the SG said. 4th, the issue cannot be decided hastily without deeper deliberation. 5th, Mehta assured the court that non-Muslims won't be appointed to the central or state Waqf boards. Sixth, until the next hearing on May 5th, no Waqf properties will be denotified or have their character altered. These include both properties declared by notification or registered as Waqf by users.
The Supreme Court has said that the Central Waqf Council and the State Waqf Boards will not be constituted. Waqf by user cannot be deleted. Now, there are other provisions also which we as a party have come to the Honorable Supreme Court that calling it unconstitutional. Now, whenever it will be heard, our counsel, Mr. Nizam Pasha, on behalf of me, will be arguing it. As you know very well that during the deliberations of the Joint Working Committee, I have given a Dyson report opposing all the amendments that were proposed by the government. And during the debate in the Parliament on the consideration or passing of that bill, I have opposed each and every amendment. I have called it unconstitutional. I still call this law as unconstitutional, as violating the fundamental rights of Article 14, 15, 25, 26 and 29. So our legal battle will continue to ensure that this act, against this act will continue.
इसके पहले भी सुप्रीम कोर्ट ने 2010 में रामराज फाउंडेशन बनाम इंडिया का सवाल उठा था, जिसमें सुप्रीम कोर्ट ने फैसला किया था कि वक्फ बोर्ड इज नॉट ए रिलीजियस बॉडी, ये एक कानूनी संस्था है जो वक्फ की प्रॉपर्टी के रखरखाव को देखती है। और इसी तरह